Jury selection began today in the federal hate crimes trial for three white men in Georgia already convicted in state court of murdering Ahmaud Arbery, who was black. William Brangham has the story.
Judy, last month, Travis McMichael, Greg McMichael, and William Roddy Bryan were sentenced in a Georgia state court to life in prison for chasing down and murdering Arbery. The federal trial will look at whether the killings were racially motivated, which wasn't addressed in the state case. The Justice Department has charged the three men with hate crimes and attempted kidnapping. Deval Patrick used to prosecute these types of cases as the former Assistant Attorney General for Civil Rights under Bill Clinton. He's also the former governor of Massachusetts and now co-chairs American Bridge 21st Century, which is a Democratic Party organization. Deval Patrick, very good to have you back on the NewsHour. So the DOJ is prosecuting this as a hate crime. And is it my understanding that the prosecutors then have to prove that these defendants had racist beliefs in their heart when they committed this murder?
That motivated the murder, and there's evidence of this in this case, and that in itself has been deemed a federal interest deserving of punishment.
So is it your sense that if the state prosecutors had introduced a potential racist motivation for this killing, that the Department of Justice might not have been interested in pursuing this?
You know, it's such an interesting question, and I'll bet it's the very kind of question that the department struggled with, because to some extent, the racial animus in the state trial, which was a straight prosecution for murder, is not relevant. It's additional color, but it doesn't make it, it's not outcome determinative, if you will, William. These are difficult cases in that sense, but they're important ones to bring because of, as I was saying earlier, the federal interest expressed in this legislation to punish racially motivated criminal behavior. And that is what this was. There was evidence of it available to state prosecutors, but they made a judgment not to use it because I'm inferring because it wasn't necessary to prove the case that was before the state court and jury.
But help me understand the concern some viewers might have, which is these three men have been prosecuted for murder. They're all going to go away for life in prison. So what is the importance of bringing a separate case that may not add anything to their prison time?
Well, it's not just about adding to their prison time, although sometimes it is. In this case, apparently not. But it's also making it clear that we are going to care about and we are going to enforce that federal interest in racially motivated violence. And that has been an issue in this country for a long, long time. Getting these laws on the books was a struggle for a long, long, long time. And you can imagine how the situations go. You know, sometimes, let's just suppose that the decision had gone the other way in the state court, and the defendants had been acquitted. Will they then be arguing that the federal prosecution shouldn't go forward?
You prosecuted a bunch of these types of cases when you were in the Department of Justice. Are these tough cases to prove the motivating intent behind a crime?
Yes, you know, beyond the fact that there is intention, a lot of times the juries don't want to hear about the racism behind it. That's been true for a long, long time. You know, let's just deal with the consequences, not let's deal with the reasons for the motivation, and that's been a blind spot, if you will, for a long time in this country. These cases are really hard. They aren't, at least when I was there, and I think still today, they aren't pursued lightly. They aren't pursued often. And there is a deference to state courts to see whether state authorities are going to take the action, and federal authorities don't have to bring a case that's quite as close. For example, William, I can understand in this case why it is the federal prosecutor tried to reach a plea agreement. I can understand it. I can also understand why Mr. Arbery's mother said no.
This was the
But you-
plea agreement that they had, the men had said, we will plead guilty and admit that we had racial animus in our minds and hearts when we committed the crime. The judge threw out that plea.
Correct, correct. Very, very unusual, William, to have the defendants not just agree to the plea, but agree to admit to the racial animus. Very unusual. As I understand it, the counsel for the family, at least initially, indicated a willingness to support the deal. But when Mrs. Arbery learned that they would be serving their term in a federal prison, which is not a comfortable place, but a lot better facility than the state facility, she said no, and the judge accepted that.
All right, Deval Patrick, former Massachusetts governor and former member of the Department of Justice. Thank you so much for joining us.
Thank you, William.